Welcome everyone. Happy Friday. My name is Rilus Dana, live again. Today I'm from my Mesa office. Last week I was live from the Scottsdale office studio. Hopefully the audio is better. We're going to do the same topic, and there's some complaints that the audio was hard to hear. So hopefully you guys can hear it better. This is a really important topic, so I want to do it again. So we're going to talk about how you can take title of real estate in Arizona. We're going to be talking specifically about Arizona today, but these principles of joint tenancy with right of survivorship and tenants in common, important stuff that will carry over to other states as well. You'll want to make sure you're getting specific advice for your state, though, whatever state that you're in. Okay, so let me go ahead and share my screen. I guess before we do that, some housekeeping. So we're doing this again, trying to get better audio. So follow us on YouTube. I may start broadcasting just in one place in an effort to do better productions. Right now I'm using some software to go live in multiple places. And, this is streaming is not just my day job. I love doing it, but I'm running a law practice and my own clients. So sometimes I don't have the time to set up all the audio equipment and all those places. So if you want to be a part of it, make sure you follow us at our YouTube, the Mott Legal YouTube. That's where I go live the most often and share content there. And let's see here. And then I want to let you know, so I'll point, let's see, right up here, that this logo, Mott Legal, this is our practice management company. So I'm going to be offering coaching through Mott Legal. And this coaching, it includes our software, our special software that we run our practice. So if you're an attorney, you're interested in improving your estate planning practice, or maybe you're thinking about switching practice areas and getting into estate planning, send me an email, talk to you more about the membership program. I did a presentation last night, the 3 Secrets workshop, 3 Secrets to a Successful Estate Planning Practice. Had a good event. We'll do it again soon. We'll do it again, same topic in the future. But for now, if you're interested in the program, if you're an attorney, shoot me an email. We can schedule an initial interview for that membership program. See if it's right for you. All right, let me go ahead and share my screen. Okay, so today's topic, we're going to be talking about title options for real estate, how you can take title of your Arizona real estate. Oops. Okay, so there's our contact information for the law firm. Dan, if you need to reach us. Real property title options. Okay, so here's Mr. Estate, our friend Mr. Estate, and buy a house. How can he take title to this house? There's options. So if Mrs. Estate, he's just solo, it's pretty simple. The title is going to be just in his name. Now, where it starts getting more complicated when you add more parties, when there's more people, more than one person on the deed. There was a Mrs. Estate, and Mr. was going to take title just in his name. He was married. He would need to designate whether this is his sole and separate property or whether it's going to be a key property also owned by a spouse, Mrs. Estate. So if you're a single person or if you're transferring property to a single person, it's going to go just in their name. But if it's more than one person, you want to designate what type of title it's going to be. And if they're married, you want to make sure you designate whether it's their community property, they're going to own it jointly, or if it's their separate property. Okay, so options. Let's talk options for multiple owners of real estate. The first option we're going to talk about is tenants in common. This is the default. So if all 4 of these people were on this deed, all of their names were on this deed, and it said Mr. Estate, Mrs. Estate, red guy, blue shirt guy, they would be tenants in common. So what that means is that they own it as tenants in common. It really affects what happens after they pass away. Where does their interest in the property go if one of these owners passes away? With tenants in common, there's no rights of survivorship. So what that means, so our red shirt guy here, I know you love the creative names here. He passes away, so his share is going to go to his estate, his children. So that's what tenants in common means. If one passes away, the share of that owner goes to their estate. Now, we know from our other videos and other broadcasts, the estate is controlled by the last will and testament. If you want more information on that, you can go find other videos on the Mont Legal YouTube. I'm not going to talk about that today, but it's just important to know that if tenants in common, one of the owner passes away, their share goes to their estate. If they have a will, that says where it goes. Okay, let's talk about the other way. Some other ways you can own property. The other major option is joint tenants with rights of survivorship. Now, I told you before, the tenants in common is what's assumed. So if it doesn't specifically say those magic words with rights of survivorship, then it's presumed there's a tenants in common. But if it does specifically say with rights of survivorship, here's what that looks like. So there's how we abbreviate it because it's so long and so many words. But if our red shirt guy passes away, so red shirt guy passes away, then the share goes to the other owners. So that's what rights of survivorship means. It means that now there's 3 owners of this property, and the share of Mr. Redshirt is not going to go to his estate. So if he had a last will and testament, or if there was beneficiaries of his estate, they would have no interest in this property after he passed away if it was held with the other owners as joint tenants with rights of survivorship. So those are the 2 major differences when you're taking property with multiple owners. You want to talk about if there's going to be rights of survivorship to pass it on, or whether it's going to be tenants in common, meaning the owners can pass what happens to their share. Okay. Taking title in the name of trust. So with the Revocable Trust, we recommend that you take title to your primary residence in the name of your trust. And the purpose of this trust is mainly to avoid probate. Again, today's focus is how you take title. We're not going to go into detail about how trusts work today. But what I want to talk about is the requirement in Arizona. This ARS 33404 requires you to include on the deed who the beneficiary of the trust is. So Mr. Estate here, he got a stealthy name for his trust. He doesn't include his name, so he wants to, trying to keep his name off the public record. Well, you have to disclose who the beneficiary of the trust is. So that doesn't work. So what if he took title in the name of an LLC? So what if he owned his house in the name of an LLC? Now, again, this is usually for rental properties and things like that. With your primary residence, people usually own it in their revocable trust. And, people know that that's their house because that's easy to look up on the public information. You're paying utilities there. You're using the address in other places. So you're already connected to this property. Keeping your name anonymous, this is more important with rental real estate and things like that, commercial real estate. The idea is if someone's hurt on the property, there's more protection to the ultimate owner if they can remain anonymous. So if the people can discover that they own a lot of assets, then it might be more likely that a lawsuit is filed against them versus if they can't tell who the owner is and whether they even if they were successful in a lawsuit, if they were that they would be able to collect something. Okay, so if you do a stealth name for your LLC, by stealth name, it just doesn't include your own name. The Arizona law requires that the articles of organization, which is a public record that you can look up, it's got to contain the name and address of the members and the place of business in Arizona. So with an LLC, you got to include the name and address of the members of the LLC. So enter the privacy trust. So people looking to remain confidential, to keep their privacy, which is an important part of asset protection. I talk about asset protection like Fight Club. It's one of those things that you don't talk about. There's no one thing that you do. It's about layers. It's about creating different layers where if there was a liability, it makes it harder for someone to collect assets. So privacy is a major layer to that. So the privacy trust, here's how it works. You create a trust with a generic name. So the trustor, this briefcase is a creator. They create it. They can be the trustee and manage it, but the beneficiary is not going to be themselves. So the beneficiary of this privacy trust, it's actually going to be the regular revocable trust, the regular family trust. Now, to remain anonymous, they need to utilize an address service. So they need someone else's name or someone else's address to be shown on the public record. So you got to give the name of the trust, which can be the generic name trust, but by utilizing address service on the record, you can list the generic name trust, care of, Mont Legal, which is our company that does the address service. So if you use someone else's address, this keeps you, boom, check it out. There's confidential Mr. Estate. He's chilling behind those shades. People don't know who the real owner is of the LLC that is owned by this trust. It keeps his information confidential. So if there was a liability, people don't know who the owner is of this generic name trust, and they don't know if they would be successful in recovering anything after they got a judgment in a lawsuit. So it's a way to provide protection, keep your name anonymous. I know this feature is also utilized by high-profile people that don't want people to easily be able to look up where they live, or maybe they're investing in a business that they don't want it to be publicly knowledgeable of. Like a lot of people invest in marijuana businesses, but they don't want their friends and people at church to realize that they actually own that dispensary on the corner. So people use services like this to remain anonymous. So I hope you found this video helpful. Remove that. If you have any comments, questions, let me know. Hopefully the audio was better this time. And I'll put up our contact information. If you'd like more information, there we go. If you'd like more information, there's our website down there below, danalegalhelp.com. Phone number is 480-924-4424. Give us a call. Check us out on the website. You can find us, you can contact us through there. But if you're interested in creating your own estate plan or creating an LLC, or if you're taking title to property and have more questions, let us know. Have a great day, everyone. See you next week.